Hi everyone. Good evening. Welcome to this webinar today. But before we start this webinar, we'd like to acknowledge the original custodians of this land, where we are coming from. So we'd like to acknowledge that today we are running this webinar or this event in the Aboriginal land, the land of Kaurna people of the Adelaide Plains region. We'd like to pay our deepest respect to the Kaurna elders and leaders, past, present, and emerging. We'd also like to request our viewers and audience who are participating from other lands and other countries to acknowledge the original custodians of their lands accordingly. So good evening again, everyone. Welcome to this significant event that Working Women's Centre and then other organizations who are co-hosting with Working Women's Centre. So this event or this webinar is targeted to international students working and studying in Australia, and also to the future international students who are thinking of making Australia as the destination country for their studies and work. We have prepared our best to make this webinar a very fruitful one, but our viewers and audiences' active participation will determine the further strength of this webinar. So we do welcome you to participate actively in this webinar through your questions and queries in the Q&A sessions. So yeah, let's start this webinar by introducing our panelists. I would like to start off by myself. My name is Umesh. I'm Umesh Acharyam. I come from Nepal, and I'm an ex-international student in Australia, but I'm currently working with a group, an organization called Adelaide Young Christian Workers in the capacity of Youth Engagement Officer. So introducing other panelists for today.
Thanks, Umesh. My name's Abby Kendall, and I'm the director of the Working Women's Centre. The Working Women's Centre is an organisation that assists vulnerable workers with workplace issues, with advice, information and representation. And we're really proud to work with all of the student associations tonight, as well as the Young Workers Legal Service to put on this webinar. So thanks very much for your attendance.
Hi everyone, my name is Ali and I'm the National Welfare Officer of the National Union of Students, which represents both domestic and international students in Australia.
Everyone, I'm Kylie. I'm an Industrial Officer at the Working Women's Centre, and I will be co-presenting part of the webinar today on how to figure out if you're being paid properly.
Hi everyone, my name's Rachel Seaforth from the Young Workers Legal Service here in South Australia. I'm the coordinator of the service, and a little bit like the Working Women's Centre, we provide completely free advice, representation, to predominantly young workers and vulnerable workers. So international students falls well within that category of people that we can help.
Hi, my name's Kelly Edwards and I work for United Workers Union. I'm a hospitality organiser, and we collectively organise work sites for workers to have better wages and conditions.
Hi everybody, my name's Tanya Chen and I work with Kelly at United Workers Union to try and help the better lives for everybody and their conditions.
Yeah, so that's everyone who will be joining us in the panel today. I might just make a start. So as I said, I'm here from the National Union of Students today. I guess for some context, as you would all know, hence you're in this call, students, both domestic and international, are generally a more vulnerable demographic to wage theft and work exploitation. That's due to a variety of reasons, but the main one we're dealing with today is about education, information, and empowerment to actually tackle the work exploitation wherever it occurs. So as you would know, a lot of the time you're entering the workforce for the first time, especially as a student. That's even more prevalent for international students who are not only entering the workforce for the first time, but are often doing so, in Australia, where it's a very foreign country that can have very different labour relations and labour laws compared to back home. Now, that doesn't mean you're entering into a different, workforce or labour market as compared to Australians. You're still covered by the same laws, and you still have the same entitlements as any other worker does. Albeit, unfortunately, a lot of students are not too familiar with all those workplace laws, given they're often here for the first time. There was a recent report done titled Wage Theft in Australia. What it found was pretty damning. So about 30% of all respondents, that is international students, earned less than $12 an hour. That's more than $6 less than the minimum wage. 25% earned $12 per hour or less, and 43% earned $15 per hour or less. So that's almost half of international students earning less than $15 per hour. And a significant more earned less than the minimum wage. Obviously, this deprives hundreds of thousands of temporary workers of millions of dollars that should be yours, that should be supporting you in your stay while you are in Australia, and helping you get the education you're here for and education you need. So what this presentation will be doing today is providing you the relevant resources and information you need, linking you to the networks you need, and empowering you to make sure not only you're getting paid correctly, but you're able to deal with any workplace issue that may arise. So we'll just move on to the start of the presentation. So we have two lawyers and industrial officers that will be conducting the presentation. We've got some slides handy, so we might just make a start.
Sure thing. Well, yes, Rachel and I will be co-presenting this portion of the webinar. Bear with me while I share my screen and get those PowerPoint going. Okay, so hopefully you can all, I'll get it. Slideshow. Okay, we should be right to go. I hope you can all see the PowerPoint screen there. Okay, so look, today we're going to cover your rights at work and common issues that international students who are working for the first time in Australia might encounter. Look, we are going to cover a lot of information today, and it's going to be a bit of an overload perhaps. We're going to try and keep it as high level as we can. But look, a lot of this information will be, like, we've got toolkits and that on our website. This webinar will be recorded, so if you miss something, you can access the recording and listen back afterwards. And there's also going to be a Q&A function on the webinar here as well. So if you have a question, we will have some Q&A time after the presentation to answer your questions. So as I said, myself and Rachel will be taking you through this little presentation. As I said before, I'm an industrial officer at the Working Women's Centre, and Rachel, as she said, is at the Young Workers Legal Service. And as explained, we're both services that are available to assist you if you do have questions, whether it's immediately after the webinar or in your future employment at some point. We're both here and able to help us, to help you. Just give us a call. Okay, so look, we'll start off talking about modern awards. So this is a really important thing to know about. In Australia, every employee is, or almost every employee is covered by an award. So that's a legal document that outlines your minimum pay and the conditions of your employment. And the awards are categorized into industries and the types of jobs that you might do. So they help you figure out what you should be paid and what other conditions that you should have in your employment. There's a minimum wage in Australia. So it's currently $19.49 per hour if you're an adult, if you're over 18. So everyone who works in Australia and is over the age of 18 should be getting paid at least $19.49 an hour. That's before tax. So it's important to know that you cannot be paid less than that amount, even if you agree to it. So even if you've said, look, I don't mind working for $15 an hour because you really need your job. Even if you've agreed to do that, it's not correct. You should be getting that paid that $19.49 an hour. So that wage is set out in the modern awards, and even if your award and your job type has a higher rate of pay, it should at least be that $19.49. So as well as that minimum wage, there's also extra amounts that you could be entitled to under the award. So that $19.49 or whatever your base rate of pay is under your award, you could get extra amounts on top of that, allowances, penalty rates, or loadings. So we'll go through those one by one. So penalty rates are something that you might get paid. You might get paid at a higher pay rate if you're working different shift times, like for instance on the weekend, on public holidays, if you're working an extra long shift or a late night shift, or perhaps you start very early in the morning. So it's basically giving you compensation for working those extra hours or working at what could be considered unsociable hours. So they're extra amounts on top of your base rate of pay, and they'd be set out in your award. Allowances are something that you could also be entitled to. So they're sometimes made to employees who have to do certain tasks or might have some kind of particular skill. It might be because you have to use your own tools at work, or if you're working in a particularly dangerous industry or job. Some common ones listed there include, if you have to wear a special uniform, you might get an allowance to purchase that uniform. If you have to, say, travel for work, if you have to drive your own car, if you have to use your own phone, or perhaps if you're working at a higher level, like if you're a supervisor or a leading hand. And some industries, like say building construction, also have extra allowances just to recognise the kind of complex or dangerous work that those workers are doing. Okay, so casual loading. So just briefly about casual employment. So we talked before about that base rate of pay under an award. That's usually for a permanent employee. So if you're a casual, you can get a casual loading on top of that base rate of pay. So at the moment, that's a 25% extra of that base rate. And that's kind of recognising that casual employees don't have a firm commitment in advance from their employer about how long they will be employed for or the days and hours they work. It's kind of more insecure employment. So it might be, say, that you're working for a job where you've got a roster. That roster might change each week. You might get, 5 shifts one week and 0 shifts the next. And it does come with the flexibility that you can also refuse those shifts if you're not able to do them. So you're not locked into that permanent employment. The employer isn't relying you on in the same way as they would a permanent employee, and you don't as well have that ongoing commitment from the employer that you will get future work. So that extra 25% kind of recognises the fact that that you are a casual. So there's an example down the bottom here. So say if you're working in a restaurant, your base rate might be $20.06. If you're a casual working in a restaurant, then you would be entitled to an additional 25% loading on top of that $20. So therefore your hourly rate would be $20.06 plus, as complicated numbers there, 25% basically. So you should be getting paid $25.07. And that doesn't include the other penalty rates or allowances that you might be able to get. So for instance, you would get more than that $25 if you were working at night time or on a Sunday or public holiday. And again, all that information is in your award. So as a casual employee, there's other entitlements that you are entitled to as well. These are covered in your award or in the National Employment Standards. So you might know if you're a permanent employee, you'll get annual leave, sick leave, and long service leave, those extra kind of things that casual employees don't. But it's important to know that even though you missed out on those things, you still can get, say, 2 days unpaid carers leave or 2 days unpaid compassionate leave per occasion. So say if you have to care for your child or go to a funeral. You also can get 5 days unpaid family and domestic violence leave in a 12-month period, and unpaid community service leave. So there are minimum entitlements that you're still that you still should be entitled to under the award, even if you're a casual employee. Okay, so now we're going to go on a little adventure to another part of the internet. We're going to go to the Fair Work Ombudsman site and try and find an award. So please bear with me while I click on this link and swap the screen sharing over to the website. This is it. Basically, they've got this facility here that will help you find out what award applies to your employment and what you should be paid. So I won't take you the whole way through it, but basically, look, there's options here. So if you're an employee looking for pay rates, you'll click here. You can click the date. So if you're looking for your current pay rate, obviously that would be the 30th of June. But if you were trying to figure out what you should have been paid 2 years ago, then you change that date. You just click next. And then it asks you, do you know your award or do you need help knowing it? So if we're looking for award, we'll click next. And then you can start typing in your occupation. So you can see I've used this before in my work here. You might be look, I've got a variety there, don't I? Funeral assistant, charity fundraiser. So say you're a cook, you can click on that. It will then show you a variety of different types of jobs that you could do in that job category. So there's quite a lot if you just put in a simple term like cook, but like I said, I won't take you the whole way through it, but you can follow the prompts. It will help you figure out which industry you're in, and then take you through and find your minimum rate of pay. And you can also go look at the full award if you want to, which is helpful because as you can see here, there's different levels of each job type. So if you're just say working in a restaurant collecting dirty glasses, you'd be say paid at level 1, but if you're opening and closing the shop, you should be paid at a higher level, and that would be catered for in the award. So I'll just go back to the PowerPoint. Okay, back we go. All right, so this is where it does get a little bit complicated, but the Working Women Centre does have a toolkit that has all this information in it about how to find out your award, how to find out whether your workplace has a enterprise agreement. That's a kind of agreement that employees might have with the business that might vary those conditions slightly, or you might have different rates of pay in them. And it will also take you through how to calculate your if you've been underpaid. But basically you'll need the information from your award or your agreement about your correct rates of pay, what you've actually been paid, and say the hours you've worked. You can then figure out if your employer owes you money. The next step would be to write a letter of demand. Again, this is in our toolkit, so I know that's a lot of text on the screen just now, but basically it's just a way of telling them that you know what your rights are, you know what you should be paid, and that they need to fix it. If they don't fix it, then that, I guess this is kind of opening the conversation and letting them know that you're serious about getting what you should be paid. If they don't, then you do have options to lodge a formal claim in the South Australian Employment Tribunal or the Federal Circuit Court, and they could have to pay penalties to you as well for not paying you properly. In either of those cases, like I said, it might be a bit much information right now, but you can talk to the Working Women Centre or the Young Workers Legal Service as well, and we can help you through that process. Okay, so I think I'll hand over to Rachel now. Rachel, you're just on mute, I think.
There we go. That should work. Hi everyone. Thanks for staying on. So I'm just gonna continue with some other things beyond underpayments that might be relevant to you in your job and might provide you with a basic underpinning of information to help you know what your rights are. The first obvious question is types of employment and what kind of work could you be doing and what category do you fall in. So I'm just going to follow through the next couple of slides and take you through different types of work and what they're called. I think next slide, Kylie. Great. So what is an employee? Well, an employee, like what Kylie has spoken about, is entitled to those minimum pay rates. And like Kylie discussed, you could be a casual employee or you could be a permanent employee, and permanent can look like full-time hours, which would be maximum 38 hours a week. Anything beyond that should attract overtime penalty rates. Or you could be a part-time permanent employee, meaning that you've got an agreed hours. So that could be something less than 38 hours a week, but you're entitled to get paid up to whatever those agreed hours are. Employees obviously get paid wages according to the minimum rates that apply to them, depending on their industry or their classification, what kind of work they're doing. They're considered a part of the business, so they're integrated in the business. So that might look like wearing a uniform or having a business email address. And they can work from home, which a lot of people have been doing during the coronavirus pandemic, or you can work at a place of business. Or, for example, construction workers could work at different work sites at any point in time. But one take-home message for employees is that you're entitled to minimum pay rates, you're entitled to entitlements often on top of those pay rates, and you're also entitled to be paid superannuation. A contractor, on the other hand, is not an employee. So a contractor is someone that is running their own business. The test in the law for this kind of thing is the facts of the case. So just because you're being told you're a contractor, it doesn't mean that you are. And if you feel like you don't have much control in the way that you run that business, then it's definitely something worth getting some advice on to just see where you stand. One of the things with contractors, which I'll talk about a little bit later on, is that if you're being paid as a contractor and not as an employee, there is a risk there that you might not be getting paid everything that you're entitled to, which is why we're talking about what contractors are now, to help you identify what genuinely is a contractor and what isn't. So contractors, like I said, run their own business. They have to have an Australian business number to do that. But keeping in mind, just because you're told to get an Australian business number, it doesn't mean that you are a contractor. So don't let that put you off or shut the door on whether you're an employee or not. Generally, contractors send invoices to their clients. So unlike an employee who is entitled to get a pay slip within one day of getting paid their wages, a contractor would send an invoice to their client for the work that they've performed and then usually request payment within 14 days or 21 days or whatever. Contractors generally buy, use and maintain their own equipment. So the construction example is a really good, clear example for you. So for example, if you're a bricklayer in construction and you're genuinely running your own business as a contractor, then you probably have all your own materials, including the cement mixer, the quick cut and whatever else is required to get the work done. Contractors can subcontract work. So that's another term for delegate work. And what that means is that contractors might get the contract or might get permission to do the work for a client, but they don't have to do that work personally themselves, and they might have other people that they get to do that work who get some of the money for doing that work. Contractors are responsible for negotiating their own hourly rate or their own payment, and so that is something that's different to an employee that is entitled to those, at least that minimum, and you can't go below, where contractors are assumed to be competitive enough to negotiate their own rates for the work that they're doing. And likewise, contractors generally don't have, for example, a roster requiring them to come in at a certain time or finish at a certain time or work certain days. They're generally given the discretion to do the work within the agreed time between them and the client, but how that work is done, or how many hours a day they put in, or whatever, is at the contractor's discretion to choose how that's going to be performed. Like I said before, a subcontractor could work for a contractor, but a subcontractor is still considered to be running their own business, so they would still have their own ABN. They would likely still have at least some of their own tools that's required to do the work asked of them. And likewise, they're not entitled to those minimum rates that an employee is entitled to, but instead they're considered to be competitive enough to negotiate their own rates that work for them. Labour hire. This is a really interesting and sometimes can be a bit of a problematic arrangement and can be quite complicated too. Essentially, if you work for a labour hire agency, you're generally still an employee. You're still entitled to those minimums that we've talked about. But instead of your boss or your employer being the place of business that you work in, generally it's the business that's paying you. So for example, you can see that little diagram down the bottom of the slide with a bit of a triangle. You've got the labour hire business at the top, and you've got the host employer to the left, and the host employer might contact the labour hire business to say, hey, I've got this sort of work that needs doing. Usually it's a temporary work or for a short term, and then that labour hire business gets paid by the host employer for providing basically the people to do the work that's needed, and so the labour hire business sends in the workers into that host employer. And so if you think that might apply to you, then your employer is likely the labour hire business and not the host employer. But in saying that, you're still entitled to be paid as an employee generally. Labour hire is really common. You can see at the last dot point, it's really common generally in apprenticeships. So for example, there's an organisation called TAPS that have a whole lot of plumbing apprentices on their books, and they find those apprentices places to work to fulfil their apprenticeship, but it's the labour hire company that is paying that apprentice ultimately. Informal labour market. So this sort of touches on, for example, cash payments. It's not unlawful for you to be getting paid cash in hand, but if that is happening to you, it is often a red flag for people like Kylie and myself, because we would be concerned about whether you're getting paid superannuation on top of that cash in hand amount, or whether that cash in hand amount represents a gross or net amount. So gross amounts refer to amounts that you're entitled to. So we talk about those minimum pay rates and the casual loadings and the penalties and everything. But the net amounts are the amounts that you actually receive. And the difference between the net amount and the gross amount is what needs to be paid to the tax office. So like I said, cash payments aren't unlawful, and it doesn't mean that your employer is doing the wrong thing, but it is something that does raise my suspicion in some of the matters that we see. Likewise, with informal labour market, if you're an employee, you're still entitled to receive a pay slip, for example. So if you're not getting any paperwork for the hours that you've worked, then again, that's something that raises a red flag, and it's probably worth just having a chat to either the Working Women's Centre or myself, just to make sure that everything is above board. So sham contracts. So I talked a little bit before about the difference between a contractor and an employee. And sham contracting or sham contracts is the situation where someone should be an employee all the facts point to them being an employee, but instead they're paid as a contractor. And when I say paid as a contractor, often what we see is that they're not getting paid enough. So their hourly rate might not be enough money. They're not getting paid superannuation. If they should be a permanent employee, they're not getting those entitlements to annual leave and sick leave. Or likewise, if they're a casual, maybe they're not getting that casual loading, so their hourly rate is incorrect. And it's illegal for employers to do this. And like Kylie mentioned before, even if you agree to some of these things, whether you understand them or not, if it's unlawful, it's unlawful, and your employer cannot pay you below the minimum. So if you think that you're in a situation where you've got an ABN and you're having to invoice your employer for money, and you're having to withhold your own tax, for example, but you think that you don't have control in the way that you run your ABN, or you think that, for example, you're required to wear a business uniform, or you've got a business email identifying the employer and not your own business, then there's some of the factors that might indicate that something might be wrong, and that's where you should definitely contact services like ours or the Working Women's Centre just to help you work through some of those issues. So I've talked about an ABN number, Australian business number, and we've talked about tax and gross and net amounts. A tax file number is used to identify you to the tax and super systems. And once you have a tax file number, it's yours for life in Australia, so you only get one. And if you don't have a tax file number, tax should still be withheld, but it's often at a much higher rate. So it can be up to 50% if you don't have a tax file number. And so that means that the difference between your gross amounts that you should be entitled to and the net amounts that you're actually getting paid will be a bigger difference. An Australian business number is used by businesses to interact with the government, like the ATO. And so, for example, if you're working for a business, they should have an Australian business number that they use to withhold your tax in. And so it just allows that paper trail for the money. Like we talked before, if you're a contractor, genuine contractor, then you would have an ABN. But just because you do have an ABN and just because you've been asked to get an ABN and that's how you work, it doesn't mean that you are not an employee. And we do often see these matters arise at the Young Workers Legal Service, and so I can't stress enough that if this is something that you're concerned about, to please call someone and get some advice. An Australian company number down the bottom there identifies a company. The difference between businesses and companies is a little bit complex, but just to keep it simple, a company is considered, in the eyes of the law, its own person. And so it's the company that's liable for your wages if you work for a company. And often a company ends with Pty Ltd. Where Australian business number, if you're just working for a person that's got an Australian business number, then it's that person that's your employer that is obliged to pay you properly. Unpaid internships. I think this is you, Kylie.
Yeah, back to me. Okay, so look, we've gone through situations about if you're working for someone and how you would get paid, but obviously there's other times, especially as a student, where you might be working and not necessarily getting paid for it, like if you're an intern or if you're volunteering. So we'll just talk a bit about when that's okay and when you should actually be getting paid, and it's not a volunteer relationship, you should be treated as an employee. Oh, whoops, back we go one. So basically, if you're studying and you're doing work experience or an internship or a work placement as part of your studies, and you're going into someone's business and doing work for them, the work that you're doing has to be for the benefit of you and your learning, and not totally for the benefit of the employer. So it has to have an educational aspect to it. You have to be actively learning. That might look like shadowing someone, or, you know, trying different types of work around the business. Yeah, you might be doing projects in the workplace, that kind of thing. It can't just be you going into a workplace and doing work like any other employee of the workplace. So yeah, you have to get a meaningful learning experience. And if it's totally separate from your education provider, then that could be one sign that it's an unlawful arrangement and you should actually be getting paid. So I'm just going to go through a few of those different situations. Okay, so a vocational placement is when you're studying at a vocational college, and part of your course requires you to complete a number of weeks or hours as work experience for credit towards your course. So although you're in the workplace doing work, the law makes it an exception for these kind of placements, and your employer doesn't have to pay you as long as that work goes back towards your course credit. So we've got a little example here of Nitin, who's studying hospitality at a vocational college. And as part of that course, he has to go into a restaurant and complete 13 weeks of work experience. So if he was there actually learning all aspects of the business, you know, and getting training on the job and that kind of thing, that would be fine. But if all he's doing is washing dishes for 13 weeks, then that doesn't sound like a learning experience for him. It sounds like his employer's taking advantage of the situation and just having him there for free labour. So in that situation, it wouldn't be lawful, and he should get paid for that work. So here's an example of Chang, who's doing an unpaid internship. She's in her last year of commerce at Adelaide University and decides to volunteer at a local firm to get some experience. The firm accepts her, welcomes her, and they arrange to do it over the winter holidays. So she's there to learn. On her first day, she's told that she gets to shadow one of the bosses, the partners of the business. She's actively going to meetings and learning about how they do things. You know, she does do some things like perhaps get a coffee here and there for the boss. She might do some drafts on things like that for the partners. But she never feels like she's obligated to be there. She doesn't feel like she's doing any work that that the business should be earning money for. And she finishes the 2 weeks with some good relationships and like an actual good overall view of the world of commerce. So although she's worked for free for 2 weeks, she has got a lot out of it for her education. So in that instance, that kind of unpaid internship would be legal. Okay, so now we're going to go through the opposite. So Fong is in her final year of an engineering degree, and same thing, she's doing an unpaid summer internship at an engineering firm. However, when she rocks up, she's asked to do work for one of the major clients of the business. So she's, you know, told what to do by the partner there. She's sat in an office and gets to work. And although you know, her manager is supervising her work, they don't really provide her with any extra training opportunities. They're not, you know, showing her around the business or providing her with extra time and to help her learn more about what she's doing. She's just sitting there, you know, writing minutes or doing very menial tasks. And the firm is actually charging the client for the work that she's doing as well as part of this bigger project. So in that situation, it sounds like that Fong should be paid. She should be there as an employee. The engineering firm is profiting from her work. She's not doing any extra educational training or learning anything more. She's just basically getting paid like getting treated rather like an employee. So in that instance, she should be getting paid as an employee should. Okay, so yeah, I think we're back to
back to me.
Rachel now for the common issues that international students might have.
So we've just picked apart 3 main issues that we see pop up that we thought would be most relevant to you guys. But in saying that, there's obviously issues well beyond the ones that we've outlined here. Sham contracting, I've already talked about that, so I won't repeat that too much, but basically the consequence of being told that you're a contractor when you should be an employee is often that you've been underpaid. And one thing that I should mention is that if you've been underpaid, you've got 6 years to pursue that underpayment. And it doesn't matter whether you're working there still or not, as long as you can claim within the 6-year time, then legally you're allowed to recoup that money. But in saying that, if you are concerned about being underpaid, whether it's by sham contracting or something else, it's always best to get on top of these issues sooner rather than later, because the higher the underpayment, it might be that the more that you need to negotiate to maybe resolve it, or you might need to be prepared to battle it out in court in front of a judge, which, you know, you can do, you're within the timeline, but obviously the more we can reduce the money that you're owed, the better. So that would be one thing. The second thing is trial shifts. It's not uncommon for us to see matters where people have been asked to work for free, essentially, to prove themselves in the hope that they get a job. Now that can be legal, but only in very limited circumstances. It has to involve no more than a demonstration of your skills. So if you are working for free for 3 weeks in the hope that you're going to get a job at the end of it, I would definitely be saying that no, you should be getting paid for that time. It has to be under direct supervision, so a little bit like internships. If you're being told to go and serve customers and you're not being supervised or there's no guidance given to you, then you're performing work that is helping that business, and you should be getting paid for that work. So the biggest advice for this kind of stuff is keep some records, keep a little diary of the free work that you're doing, some of the tasks that you're doing, and whether or not you are supervised. And if you are concerned that you have worked for free for too long, or in a job that you should have been getting paid, then definitely call one of our services for some advice on that. And like I said, you've got 6 years. Dismissals. This is a whole topic in itself, but I will try and keep it simple. If you don't remember anything else that I say about dismissals, just remember you've got 21 days, even if that's the only thing you remember. If you've been dismissed, you only have 21 days to lodge a dispute for that. So if you're concerned even slightly, please call one of our services within that time. There are 2 types of ways you can dispute a dismissal, and the first is whether it's an unfair dismissal. So some of the criteria that is relevant in making that assessment is, for example, were you given any warnings? What was the reason for the dismissal? Were you able to respond to any allegations against you? Were those responses considered? Were you able to have a support person in any meetings that might lead to a dismissal? And so if any one of those things hasn't applied to you, so for example, you've received a text randomly, you're dismissed, we don't like the way you've done the job, and that's, you've never heard that kind of criticism before in that employment, then it might be reason to give someone a phone call. With an unfair dismissal, there is some eligibility criteria before you're able to make that argument. That is essentially that if you're working in a business with less than 15 people, you have to have been working there at least 12 months. And if you haven't been, then unfortunately, even if it's unfair, you can't dispute it in the unfair dismissal pathway. If you're working in a business with more than 15 or 15 or more people, then you have to be working there at least 6 months. If you're not eligible, so you haven't worked there at least 6 or 12 months, don't lose hope. It's still worth calling someone and getting some advice within the 21 days, because the second way you can dispute dismissal is called general protections. And that's that last dot point which talks about unlawful dismissals as opposed to unfair dismissals. To give you a bit of a difference between the two, unlawful dismissals might be because you've complained about your pay rates, or let's say you've identified that you've been underpaid and you've raised that with your boss, and you might have only been working there 3 weeks. If your boss dismisses you or fires you, or even cuts your hours or demotes you because you made that complaint, then that is unlawful, and you can dispute that in the general protections pathway of disputing a dismissal. Likewise, and so anything related to a workplace right, any sort of unfair or negative action against you because of a workplace right, whether it's about your pay, whether it's about safety issues, anything like that, if you've been dismissed because of that, definitely call someone. Dismissals can also be unlawful if they're for a discriminatory reason. So discrimination can extend to your race, religion, culture. It can even extend to if you've got family and carer responsibilities and they've dismissed you because of that. So there's a lot there to explore. Every case is different. And if you think that your dismissal doesn't sit right or isn't fair, call someone. And also, interestingly, you can't be dismissed because you're temporarily absent due to illness. People get sick, they can't come to work, and you shouldn't be fired for that. And that applies even if you're a casual worker. So as we've learned tonight, a casual worker isn't entitled to sick leave. But even if you are a casual worker and you're not taking sick leave, but you're still too unwell to come to work for a temporary period of time, then you can't be dismissed for that. I suppose the biggest take-home message for any issues that you might have in anything in your employment is to try and keep everything in writing and try and keep as many records as you can keep, because if there is an issue, it's those records that are really going to help you if you need to go down a legal pathway at any point. Next slide. So we're going to touch a little bit on your visas, student visas, and how to protect yourself, because we do understand in our services that the visa conditions can often be a real big concern for international students. And likewise, often they can be a bit of a bargaining chip for the employer to prevent you from pursuing your rights. I just want to say from the outset, though, that I'm not a migrant worker, I'm not a visa lawyer, sorry. So I'm not an expert by any means on this stuff, but I can certainly give you some dot points to take away. And if you've got any specific questions relating about your visa, then feel free to give one of our services a call. Or likewise, in a couple of slides' time, there is a link to a website where you can find out what your conditions are as well. So putting that out there, the Department of Home Affairs takes the view that it's your responsibility to know what your working conditions should be or what your restrictions are. Those conditions should be outlined to you in your visa grant notification letter. But typically, generally speaking, student visas allow you to work no more than 40 hours a fortnight. There are some exceptions to that. So, for example, if you're doing a master's or a doctoral degree, and generally the limit of working hours applies during semesters. But again, if you are not sure what your conditions are, then have a look at that notification letter you should have received, or in a couple of slides' time, go visit that website and find out exactly what your conditions are. Next slide. So if you've breached your visa, now it's not uncommon for us to come across international students that have been put in a really hard position where they're not getting paid what they should be getting paid, and they've been forced to work more than they should work, and that's just simply live. And if that's you, then call someone. But if you have breached your visa and the Department of Home Affairs decides to investigate a suspected breach, then the first thing you should receive is a notice of intent to cancel your visa. And that means that they're investigating the issue, and you should have an opportunity to respond with some reasons as to why or why not you haven't breached that visa. So if you've breached it, you can respond with some reasons. And some of those reasons, for example, could be that you're underpaid, you were coerced, or you're forced to work, things like that. Again, I'm not qualified enough to give you specific advice on this stuff, but if you are in that situation, I'm more than happy for you to call either of our services and have a chat about it, and we can certainly help where we can. It's also mentioned in the dot point that they do consider the degree of hardship that might be caused, and whether there are extenuating circumstances. That means circumstances beyond your control into what caused you to breach your visa. But like we said, every case is different. So please call someone if you find yourself in this situation. And a takeaway message that I would take, bringing it back to your right, even if you've worked beyond the 40 hours a fortnight, in the employment space, you're entitled to be paid at the minimum for every single hour that you have worked. So if your employer is telling you, oh no, you don't get paid for more than 40 hours a fortnight, but you're working much more than that, then definitely call someone, because you could have an underpayment issue as well. So how can you protect yourself? Well, firstly, if you find yourself in a position where your employer is kind of using your visa as a threat against you, or making you work more than what you're allowed to work, the first point of advice would be to try and get yourself out of that situation as soon as you can, to avoid breaching that visa. We would never advise you to breach your visa conditions. But in saying that, employers are also responsible for ensuring that visa holders don't breach this restriction. They're responsible for knowing what those restrictions are. You can see the website down the bottom, the link that's provided there, that will allow you to check what your conditions are, and you can also provide your employer with your visa details as well, outlining your conditions, so everyone's aware from the outset that, this is what I can work and that's it. Next one. And so that's it for today's slide. I think we're going to have a bit of a Q&A, but like we've said throughout the slide, there's our contact details there of both the Young Workers Legal Service and the Working Women's Centre. We can both equally help you guys with any issues that you might be having, even if it's just to call and get some advice, or just to make sure that things are above board. And so I would encourage anyone that is a little bit concerned after today's chat that their employment might be doing some things wrong, or that you might not be getting paid what you're owed or whatever, to certainly give one of our services a call so we can help you work through that issue.
Definitely.
Great, thank you. Thanks so much, Phil and Kylie. We've got a couple of questions that have come through the Q&A, so I might just shoot them over to you. So the first one's from Marilyn, and she says, thanks for sharing all the info, but she just wanted to know whether, if she's left her employment, can she pursue her employer for the underpayment? That is, she's already left her employer, the underpayment happened previously, what can she do about it?
Yeah, I'll take that one if you like. So look, you can definitely do something about that, even if you're no longer working for that employer. You've got 6 years, as Rachel said, to pursue that money claim. So you can go back 6 years and calculate your underpayment for that time. And yeah, even if you're not working there anymore. So as long as the underpayment happened within 6 years of the date that you lodge your money claim, then you can most certainly go back and try and get what you're owed.
Great, thanks Kylie. And then we've got also a couple of questions about recording hours. So there's a question about how you might record your hours if you're working on an ABN. I guess sometimes you might, if it is in fact a sham contract, as you were talking about, Rachel, an international student might be paid per job or per gig. But if they are an employee, then it will be important to record that, how should they do it?
There's no right or wrong way to do it. Really, the information that is useful when we think about an underpayment is days that you've worked, because obviously we know that there might be different pay rates for Monday to Friday as opposed to Saturdays and Sundays. So you want to start off recording the day that you're doing the work. Secondly is your start time and your finish time and the total time that it takes for you to do that piece of work. And obviously factoring in any breaks that you might have during that period, because breaks are generally unpaid. So you want to record the date, the day, and the time started and time finished of doing that work. And then that will help us, if you are in a sham contract arrangement, that will help us to go back and calculate what your hourly rate should have been according to the hours that you've worked.
Yeah, great. Then we had another question. Well, it was sort of a question and a comment, but one of our attendees has told us that he or she was working in an unpaid internship in an IT firm as a digital marketing assistant. They said they didn't learn anything new, and they were there for nearly 2 months. Does that mean it's legal, or should they have got paid for their time there?
Well, look, I think like we talked about, if you weren't learning anything new and your education provider wasn't involved at all, then look, it might be that you should have got paid for that time and that you could put in a money claim. But I suggest it might be a good idea to give one of our services a call so that we can go through all of the facts and look at, your contracts and what work you were doing and your courses as well, and just have a chat about whether we could advise you to put in a money claim or not.
Great, thanks, Kylie. And I think that's all of our questions for tonight. It's probably a good time to segue to Umas, who's going to talk to us a little bit about some of the issues that he comes across while he's organising international students. So Umas, are you there?
Yeah, thank you, Abby. Yeah.
Nice. Yeah, so that's a pretty interesting story from one of our attendees, and probably something that you see quite a bit, working for nearly 2 months in a job that sounds very much to me like not like an internship job, but something that you should be paid for. What are some of what sort of issues do you come across in your everyday work?
Thank you, Abby, for that. I think in the presentation, we have included a lot of those scenarios that we face with young workers that we are in contact with in the formal and also in the informal way. So one of the significant worker rights violation scenario we see is through the Sham contracting, in those practices. So a lot of students get involved in work in ABN number, and then they are not sure if they are a contractor, or they themselves do not understand the differences between working in TFN or ABN or ACN and things like that. And a lot of the times these jobs are advertised that the worker is required to have an ABN, have an ABN number. But when we look in the cases, we actually see that those workers are actually employees, not a contractor. So that is absolutely one significant scenario we come across, in the daily kind of thing. So that is one thing. And then also in the participation in the informal economy through cash in hand works, you get paid a couple of, $50, $60 in cash in hand, things like that. And then there is no formal process. There is no pay slips or anything like that. So it is just cash in hand economy, so there are a lot of issues in that too.
What sort of industries do you find that happening in? Is it very particular industries or across the board?
Yeah, I think there are 3 major industries where international students get into Australian labor market when they first come to Australia. Is cleaning industries, hospitality industries, and nowadays we have been seeing some things around agriculture and horticulture industry too. So these are the 3 major industries that we come across, international students participating in. Yeah.
Yeah. Okay. And I suppose we just thinking about, we've had a lot of students come through the centre recently who have been in the cleaning industry, and they've had an ABN, but their boss tells them to work from 6 a.m. to 9 a.m. and then they start working again at sort of 3 p.m. to 6 p.m. or 7 p.m. And they're paid less than the minimum wage, but are told that they are a business in themselves. They have this Australian business number, and so of course when you calculate the underpayment, it's quite significant. So do you have can you kind of give us some examples of some sort of stories of people that you've come across?
Yes, surely. With the Sham contracting practices, I think if you look into different social media, Facebook pages where jobs are advertised and things like that, we see there is so much huge interaction because as we know, like there are like lack of jobs at this moment itself and before COVID also. And then we could see like these jobs being advertised in different social media pages, and then like requirement of ABN and things like that. But there was no like any kind of like description written about like what kind of job it is, when it is taking place, who are the things like that. So there are like so many stories in that one. I think I would like to share another story, which is another interesting industry. I think that is car washing industry. So last year we came across a couple of workers in one of the car washing site who were there like early morning, like around 6 o'clock, 7 o'clock, and then they were not called in at the time. So they had to be present there every day in the hope of finding a job. So if there are cars coming in, then they will get a job. Otherwise, they won't get a job. So that is like they're spending like 4 or 5 hours of their time, like just waiting for the job to arrive. And that was like very sad to see that, because these were like young workers who were like spending their entire morning and then entire afternoon, sometimes quitting their studies also. Sometimes they leave their classes because the possible employer would call them like come for a work today, and then wait for the cars to arrive. So that was like one common practice that we saw like 1 year back with a couple of our contacts there. Similarly, we come across stories where it is very interesting to see this also, and a lot of workers find it difficult to prove that they are getting exploited, like in legal terms. For example, there was one worker who said that he works from like around 5 o'clock to, like 5 p.m. to 12 a.m. in the night in a restaurant, and then get paid like $70 or $80 or $60 a shift. And then, but that was reflected in the TFN. But the hours that the employer would give is like around 3 hours work, which would like sound perfectly legal, but at the same time you are just getting paid around like like less than half the minimum wage that would have been to be paid to him. So, and when I was talking to him, he said like he doesn't have any kind of like paperwork to show, because in his taxing it is reflected that he has worked just for like 3 hours and then getting paid perfectly legal amount in those paperwork. So that was interesting to see that. Yeah.
It's funny, as Kylie and Rachel is saying, where you're recording your hours, often people will go to work and work those crazy hours and they won't write down when they start and finish. But that doesn't necessarily mean that they can't find out when they started and finished. I mean, how often do we all, when we go to work, we message someone and say, I am going to work now? Or when we knock off, we message someone and say, I just knocked off. If you go through your text messages or you go through your Google Maps, if you have your location services on, and of course that's a whole nother problem in itself, but you might be able to find when you did in fact start and finish and where you were at particular times and piece it together. So you don't need a perfect spreadsheet about when you started and when you finished. Of course, if you can do that, then great. And in fact, there are some apps which will link everyone to where you can plug it in when you do start and finish, and it provides you a spreadsheet. But you while going through your phone or going through other kind of informal records, you might be able to piece it together.
Perfect. Yeah, that's true, Abby. And I think there's one more story I would like to share, and then it could be a question to our experts, panelists also. For example, we see a lot of workers, like employed by a subcontractor, and by the time they become like empowered enough to talk about it or decide to come forward, they would not find anywhere where that subcontractor is. Like there is no presence of that subcontract anywhere. So this is just my question to you. I don't know. So what could be done in that scenario when they can't locate their employer or the subcontractor they were working with? Is there any?
So that's the question is, like, you realize that you were an employee and you've been underpaid, and then you go to figure all of that out, but you realize that the company that was employing you has just disappeared.
Exactly.
Okay. Well, Rachel, what do you think about that?
That's a really complicated question, and there's a few things that go through my mind. I suppose it depends who you're working with. If you were working for someone with an ABN, like we talked about, that person personally may be responsible for your wages, and so it'd become a bit of a finding mission to try and find that person and locate them. If, on the other hand, you're working for a company with an ACN, unfortunately, if the company has gone into liquidation or are insolvent, so basically what that means is the company is dying and they're closing down. If that is the case, then you might be limited in how you can get those entitlements back. They may die with the company, but in saying that, we could certainly help you to try and find out whether you're eligible for the Fair Entitlements Guarantee System, which is something that is designed to, I suppose, pay you something as opposed to nothing if you think that you are entitled to some pay. But you need to be eligible for that, and every case is different. So it's something that we would certainly recommend that you get some advice on if you're in that situation or you have those concerns.
Thanks, Rachel. I think a lot of these employment law issues are very complicated. And, in all of our jobs, we find that there are just thousands of facts. So, if you hear something tonight and think that you're totally locked out, well, it might not be the case, and you really should give us a call, as Rachel and Kylie have both spoken about. But another thing that you can do, and you can do as a collective, is to join your union. And one of the things that we wanted to talk to students about tonight is, what are the steps that you can take to protect yourself before you have a problem, and when you enter into a new workplace, or when you first get to Australia, or sometime in between. And so we thought it would be an excellent opportunity to have a union that covers a lot of international students in the industries they tend to work in. So, hospitality, cleaning, agriculture, here to discuss some of those options. So, Kelly, I might just ask you to introduce yourself again and kick us off and tell us what you're all about.
I'm here with Tanya Champs, and we're organisers from United Workers. Oh, I'm sorry about that. Our reason for being here today is to inform you about unions and the benefits of being a union member. United Workers is an amalgamation of two unions, United Voice and the NUW. Both unions came together on November 11th, 2019 to form the new United Workers Union. United Workers Union is made up of 150,000 workers across the country and from more than 45 industries such as hospitality, aged care, call centres, cleaning, food and beverage, all standing together to make a difference. The work that our members perform reaches millions of people every single day. They are the people who feed us, educate us, provide care for us, and keep our community safe. Without our members, everything stops. The United Workers Union and its members will together unleash the collective power of workers to transform their lives and their communities and put the voice of workers at the heart of the economic and political system. Our mission is to build a new democratic union of organised workers taking action to make change for today and for future generations. Anyone working in Australia can join their relevant union. This means if you're on a visa that allows you to work, you are eligible to be a union member. Together, members across the country fight for things like fair wages, regular hours of work, safe working conditions, respect for women, the right to weekends and holidays, long service leave, the right to protect from unfair sackings, and access to superannuation. All of these came about because the men and women of Australia Australia's union movement chose to support campaigns to create a better future for us, their inheritors. This work continues up to the present day. We commit to stand with working people in their workplaces and their communities. We stand with migrant workers, women workers, young workers, older workers, workers with disabilities and unemployed workers. Our Jobs You Can Count On campaign will continue to connect and organise workers exploited by poverty, wages, insecure work, labour hire and contract work. All workers benefit, lost my place. All workers benefit from unions because unions set pay standards and workplace protections. Union members, workers like you, benefit from the union's collective bargaining power to negotiate with employers on their behalf. This basic right gives you, as a union member, more power than if you try to negotiate as an individual. Unions help protect employees from the unjust. I'll now pass over to Tanya and she'll give you an example of a win from an exploited visa worker. There you go, Tanya.
Kelly. United Workers Union member Ms. Abraham was found to have been discriminated against based on her immigration status during her employment at an Indian restaurant. The Civil and Administration Tribunal heard that Ms. Abraham was forced to work up to 70-hour weeks and her wages were mishandled through a cashback scheme. Ms. Abraham, who started her job at the restaurant in January 2018, told the tribunal that she was required to pay her boss $100 per day for each day of leave she took and $511.40 in cash each fortnight for what she thought were her tax requirements. We know the abuse of Australian workers due to their visa status is widespread. It is difficult for those to get justice and to make a real change, but employers who steal from their staff must be held accountable. A quote from Ms. Abraham: "I would like to say to people who are suffering this, come forward. No one needs to suffer like this. It is modern slavery. So please come forward and tell your story." I let the union know what was happening and they helped me understand my rights and encouraged me to take action. This decision is groundbreaking and the first of its kind. We really hope it signals to workers in similar situations that they can seek help, they can pursue their rights and that their union is here to help them. Workers shouldn't have to worry about their bosses ripping them off, and this corrupt behaviour has got to stop. Union members like Ms. Abraham will continue to fight to restore the notion of a fair day's pay for a fair day's work for every worker. The union also helps members on a number of collective issues in the workplace, and we also provide assistance for individual matters, some that were mentioned by Kylie and Rachel's presentation earlier. And these items are such as underpayments of wages and superannuation, leave entitlements, bullying and harassment. This work is done by our Members' Rights Centre, which is a team of legally trained professionals who have extensive experience in resolving workplace issues for our members. Today, unions are more important to working people than ever. Changing technologies are revolutionising many types of work, yet workers still require united strength to assure themselves of individual opportunity, dignity and advancement. As soon as I finish, I'll pop up a link in the chat for both our website and our Facebook page. And we would just like to thank everybody for listening this evening. And just remember that by joining your union is the best way to secure a better life for yourself at work and at home. Thank you.
Thanks so much, Tanya. That was wonderful. And thank you to everyone involved tonight. We put this webinar together by really strengthening some already existing partnerships, but creating some new partnerships between the Working Women's Centre, the Young Workers Legal Service, all three university student associations. So that's the Flinders Student Association, the Adelaide University Student Association, and University of South Australia Student Association. And of course, to the Adelaide Christian Young Workers as well. So we had asked what is really important to all of our organisers, and of course the National Union of Students. We are all committed to creating a stronger safety net for migrant workers and in particular international students in Australia, and specifically South Australia. And this is really the first of many events that we're going to do in order to strengthen and build that safety net. So we will send you a recording of this. We had over 100 registered tonight, so we know there's a lot of interest in this topic. We'll keep going. We'll send you all of the information. You can share that information with as many people as possible. And we'll also just send you a short survey as well to see what you thought of it and see where we can improve so that we keep delivering some excellent webinars and events for you. So thanks very much for tuning in tonight. We really look forward to the next time we see you. Have a great night.